Good morning, everyone. I'm Judge Corey Amanda Cawthon, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. As a reminder to everyone, today is not your trial date, and so I do encourage you to speak to your attorneys before speaking on the record today, because everything that we say is being recorded and can be used against you at a later date. For those of you represented by the Public Defender's Office, know that attorneys from the Public Defender's Office are present both here in the courtroom with me and at the main jail. For those of you at other facilities, know that these attorneys are available to you by phone. For those of you represented by private counsel, know that your attorneys come here to the courtroom with me and are able to address your cases from here. If your attorney is not in the courtroom when I call your name, you can let me know that, and we will see how we can help facilitate that process for you. However, I ask you not to tell me that you have private counsel unless you or your family have already retained counsel for this specific arrest. You also need to know that in the courtroom with me, I have present attorneys from the State Attorney's Office, as well as representatives from confinement status, pretrial supervision, and the Clerk of Courts. All of these persons are here to help facilitate this morning's session and to provide any additional information that may be needed. Some of you may be able to resolve your cases here at first appearances if you are here on misdemeanors or municipal ordinance matters, but understand that is dependent on what is going on with you personally and with your case. For those of you present this morning on felony matters or violations of probation where the judge has already set a no bond hold, know that those cannot be changed or resolved here at first appearances. Following today's hearing, your case will be assigned to a specific division judge, and going forward, all pretrial motions and any subsequent trial will be heard before your division judge. As we are getting started this morning, I'm going to first go to our cases that the jails have requested to be called out of turn, and then I'll go to our sign-ins after that. We'll start off with the cases at Maine that were requested to be called out of turn. First up is Matthew Otero.
He's approaching. Judge is here at Maine.
Thank you. Good morning, Mr. Otero.
Good morning.
Mr. Otero, you're before the court this morning on 3 charges. Count 1, DUI, alcohol or drugs, first offense. Count 2, DUI with damage to property or person of another. Count 3 is failure to use due care. That count is not for magistrate. I find probable cause for these charges, and I will hear from the parties at this time.
Judge, this being Mr. Otero, my understanding, Judge, is basically this is his first time being arrested. He's been in our community living here his whole entire life. He's 22 years old, a graduate of West Broward High School class of 2016. He's currently going to school. He goes to Broward College studying graphic design. He lives with his mom in Pembroke Pines. Judge, considering that he has no prior contact with the criminal justice system, I'm going to be asking if the court would consider releasing him ROR. If not, at the very least, Judge, if the state has an objection to that, we'd just be asking for for the court to consider ROR on count 1, and then I would be contacting his other after court to go ahead and post a monetary bond on count 2.
No prior record? All right.
Good morning, Your Honor. Jason Goldsmith on behalf of the state. State's asking for ROR with pretrial release.
Mr. Romero, have you discussed standard pretrial with him?
I did, and that's why I asked. Since it's his first time with, I don't think he's going to school. He's graphic design. I don't think that's reasonable. So I'd ask you to just leave the bond in place if the court's not comfortable with straight ROR, or at the minimum an ROR on count 1. So his mom just could go ahead and post a bond on count 2.
All right. I will ROR him on count 1, and I'll leave the standard bond in place on count 2.
Thank you, Judge.
Thank you.
I'll contact your mom later when I get out of here. Go.
All right. The next is Nicole Peliquin at Maine.
She's approaching, Judge.
All right. Good morning, Ms. Peliquin.
Good morning.
You're before the court this morning on 3 charges. Count 1, possession of alprazolam. Count 2, possession of methamphetamine. Count 3 is a municipal ordinance violation for open container. All right, I'll hear from the parties.
Judge, and speaking Ms. Pelican, my understanding is she has no prior record. She's been here her whole life, 27 years old, a registered voter in our community. She lives in Boca with her mother. Judge, if the state can confirm she has no prior contact, considering this is a not violent offense, I'm going to ask the court to consider a straight ROR on Ms. Pelican's behalf. If otherwise, then I'd ask the court to leave the bond in place. I'm going to be contacting her mom to post her monetary bond.
The defendant has no prior record.
A state would recommend to keep bond in place.
All right, based on the nature of the charges and the fact that there are no priors, I'm going to, number 1, make a finding of probable cause, and number 2, I will grant Ms. Peliquin an ROR on these charges.
Yeah, listen to the judge, she's going to instruct her.
Ms. Peliquin, so that you understand, though I'm giving you the ROR and you're going to be released today, that does not necessarily mean that's the end of the case. So it's going to be your responsibility to be in contact with your attorneys in the clerk's office so that you know if there are any future court dates you need to be present for. Do you understand that? All right, and Mr. Romero's given you some information there that includes some ways to keep in contact for that, so make sure you read that after today's hearing. Good luck to you. John Palmer.
Please approach the judge here at Maine. Come on
Thank
up,
you.
sir.
Good morning, Mr. Palmer. You're before the court this morning on 1 charge of robbery by sudden snatching without a firearm or weapon. I find probable cause, and I will hear from the parties.
Judge, when I spoke to Mr. Palmer, my understanding, the conversation he had with law enforcement was different from what's written down here. He thought after his conversation with law enforcement he was going to be charged with disorderly conduct. That's not the case. I did inform him it's a robbery by sudden snatching. From what he advised me, Judge, he's 47 years old, been living here his whole entire life. He works off and on, Judge, doing side jobs, landscaping, but really he's financially indigent. He's homeless. He does have a mailing address to get future correspondence to make sure he comes back to court. Judge, considering the offense, I'm going to be asking for the court to consider a $2,000 bond on Mr. Palmer's behalf, Judge.
I show that Mr. Palmer has been arrested at least 56 times.
How many?
Not only here in Florida, but also in the state of Georgia, if the court wants me to go through it.
Did you say 56?
Yes, ma'am.
Okay. Pretrial's advising me that he has over 56 prior arrests, both in Florida and Georgia.
I can go through the court if he wants me to do that. I see.
Can you just tell me what the most recent is? I don't need all.
Was arrested for a robbery in Miami-Dade County. I don't have a disposition on that as of yet. I see where he went to Florida State Prison, and his release date was
It's August 29th, 2019.
It's 29, 2019.
that
The
was
release.
after he violated his probation, and the charge that his probation was violated on was altering and destroying, removing physical evidence, and possession of paraphernalia, grand theft of a motor vehicle, 2 counts. Correct? Correct. It's a lot of information the court wants.
That's all right. That's all right. What is the state's recommendation?
Your Honor, the state's recommendation is $7,500.
The bond will be set at $5,000. There will also be an order of no victim contact. Mr. Palmer, whether you know the alleged victim or not, so that you understand that no contact order, it means no being in the same place at the same time as this person. That includes no phone calls or text messages to this person and no third-party contact or social media contact with this person. Do you understand that, sir?
Yes, ma'am.
All right, thank you.
Judge, one other, request.
Yes.
If we could go ahead and sign a property order so he can access his property, he believes he has phone numbers and information in his
All right,
property.
that's fine. Thank you. All right, and then I have a couple of cases from Conti that have been requested to be called out of turn, so I'll go to Conti now.
And Judge, I got a
Yes.
call from North Broward. They're requesting another, feel same on page 15.
Same. Okay. All right, so let's start with Mr. Roberson's case. Good morning, Mr. Roberson.
Yes, good morning. How you doing, Your Honor?
I'm well, thank you. And Mr. Roberson, you're here this morning on an ad charge. This is a charge for grand theft. I find
Yes.
probable cause, and, Mr. Miller, do you wish to be heard?
No, as far, I understand he's got several no bond holds, so in light of that, we have nothing to say at this point.
Okay, all right, anything from the state?
No, Your Honor.
All right, so Mr. Roberson, in light of the other no bond holds that are pending, I'm gonna leave the $1,000 standard bond in place on this charge.
That's all right, Your
All right.
Honor. Thank you. And I have one concern, Your Honor.
What's that?
On count 7, I see that it says pending Nubia hearing. I
A
don't
Nebia
understand.
hearing.
Nubia hearing?
That's regarding your bond, so you can discuss that with your attorney, Mr. Roberson, and he'll advise you as to exactly what that means, okay? It's discussing the bond, though, just so that you understand.
Okay.
All right, good luck to you, sir.
All right, thank you.
You're welcome. All right, next will be Michael Miranda at Conti.
He's in regular court this morning, Your Honor.
Okay, this is an ad charge, and is your office representing him, Mr. Miller?
I believe so, Judge. I have no objection to the court passing this through.
Okay, all right, I will make a probable cause finding in absentia on the ad charge, and, I believe Mr. Miranda has other, burglary charges. I don't remember what we set the bond at on those, though. Mr. Goldsmith, on Mr. Miranda's ad charge, what is the state's recommendation?
Just one moment, Your Honor.
Okay.
State's recommendation is $2,500.
All right. Mr. Miller, any objection?
None, Your Honor.
All right, the bond on that will be set at $2,500 then. Okay. All right, and we'll now go to North Broward, so we can address Mr. Phil Sames' case.
Judge,
Good morning, Deputy. All right, good morning, Mr. Phil Same.
Good morning.
Mr. Phil Same, you're before the court this morning on 2 charges. Count 1, possession or use of drug paraphernalia. Count 2 is trespassing on an occupied structure or conveyance. I believe I've already found probable cause in this case, and we are addressing bond today.
well, Judge, we were hoping we could resolve this case if the court is so inclined.
All right, let's see. Does the state have an offer for Mr. Phil Same?
One moment, Your Honor.
Okay.
Your Honor, the state's offer is an adjudication, time served with no return.
All right, so Mr. Phil Same, if you would like to resolve this case today, the state's offer to you would be an adjudication of guilt with time served, and there would be a no return order to the location of the trespass. Do you understand that?
Understand?
Do you wish to accept that offer today?
Yes, I accept it.
All right, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes,
Thank you, and now you can put your hand down. And Mr. Phil Same, do you understand everything we've discussed so far this morning?
yes,
Is anyone forcing you to resolve this case?
no,
Are you under the influence of drugs or alcohol?
no,
Do you need any more time to speak with your attorney?
no, I don't.
Okay, and do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes,
Have you ever been treated for mental or emotional illness?
yes,
Is there anything about that illness today that impacts your ability to accept this plea?
no,
Okay. And do you understand that if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
I understand.
All right, and Mr. Filsaime, what plea do you wish to enter? Guilty or no contest?
Guilty.
All right, I accept your plea and find that it's freely and voluntarily given. Once again, your sentence will be an adjudication with time served, and there's a no return order to the location we discussed. You understand that?
I understand.
All right, thank you.
Adjudication, so when will I be out?
You'll be released today,
Today?
sir. You'll be released
Okay,
today.
thank you.
Good luck to you.
Thank you. Thank you.
Okay, so now we're gonna start with our sign-ins. If I have this person present, on page 21 is Courtney Coney. Okay, let's see if he's there yet.
Your Honor, we're gonna bring him in.
Okay, just let me know. Thank you.
You're welcome.
Judge, and does Courtney Coney have their own attorney as a family?
It's family.
Okay, so I need a chance to talk.
Okay,
thank
just let
you.
me know when he's ready. All
I will.
right, so then how about on page 18, Joseph Beret? His counsel is present if you have him.
Present, Your Honor. I do have it. And family's present as well.
Yeah.
Adam Goodman on his behalf.
Thank you. All right, thank you, Mr. Goodman.
He's approaching, Judge.
Thank you. All right, good morning, Mr. Beret. You're before the court this morning on 3 charges. Count 1, aggravated assault with a deadly weapon without intent to kill. Count 2, burglary of an occupied conveyance unarmed. Count 3 is criminal mischief greater than $1,000. I find probable cause for these charges, and Mr. Beret, as you can see, your private counsel, Mr. Goodman, is present with me in the courtroom. At this time, I will hear the parties' recommendations.
Your Honor, I would actually argue there's no probable cause for count 2, burglary of an unoccupied conveyance. There's no allegations that he entered the vehicle, that he crossed the threshold of the vehicle. So I think on count 2, it actually should be an ROR. With regard to the criminal mischief over $1,000, I do agree there's probable cause. The ag assault with deadly weapon, depending on how fast the car was going, but I could argue that could also be considered part of the criminal mischief. But I would argue that with regard, the state had told me that they were going to be recommending a $10,000 bond on count 1, $2,500 on count 2, $500 on count 3. I would be asking for a lower bond on count 1, an ROR on count 2, and an ROR on count 3. He is been in the South Florida area for approximately 36 months. He's 61 years old, no criminal history. He is a disabled veteran who is honorably discharged, does not currently work. His wife is present in court. He's got ties to the community. The victim in this case was on his property. It was on the swale of his property, conducting work. So at this point, we'd just be asking for some sort of reduced bond, considering his ties to the community, his lack of criminal history, his service to this country, those type of things. And I don't see the probable cause on count 2 at all.
Well, I think at a minimum, I can find probable cause for attempted burglary of an occupied conveyance based on the allegations in the probable cause affidavit.
That I would agree with, Your Honor, but not an F2.
All right, I will make the correction to attempt. And Mr. Goldsmith, I just want to confirm, based on what Mr. Goodman just told me, the state's recommendation is $10,000 on 1, $2,500 on 2, and $500 on 3. Is that correct?
That's correct, Your Honor.
All right. So, Mr. Goodman, for count 1,
I would maybe ask for 5,000 or 2,500 for count 1, and then an ROR on count 2 and 3. He's got no criminal history. Odds are this is going to end up in probably try to move into veterans court at some point, and.
state confirmed that there is no prior criminal history. All right, what I will do is on count 1, the bond will be set at $5,000. On count 2, the bond will be set at $2,000. And count 3, I'm going to leave the standard bond in place at $500. There's also going to be an order of no victim contact. Mr. Beret, I don't know if you know the alleged victim in this case or not, given the circumstances, but so that you understand the no contact order, that means with respect to the alleged victim, no being in the same place at the same time as this person, no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that, sir? Okay, I can see. Hi, can one of the deputies turn the speaker on there so that I can hear Mr. Beret? Thank you. Okay,
Thank you.
all right.
Your Honor, they're doing work in front of my house.
Okay, hold on one second.
Joseph, don't say anything,
All
don't
right.
say anything, it's fine.
Okay,
All
I'm
right,
sorry.
that's fine, Mr. Bray. I just want to make sure you understand the no contact order, and you can address everything else with Mr. Goodman, okay?
Thank you.
Thank you.
All
Thank you, Your
right,
Honor.
thank you. Good luck. Okay, and then waiting on Mr. Shake to come back. Okay, so while we're waiting on Mr. Coney and we're waiting on Mr. Shake to come back on the MO cases, I'll go ahead and go down our regular
Mr.
list.
Cooney's here, Your Honor, I'm
He is
sorry.
here, okay. As, Mr. Romero, Mr. Romero, do you need any more time to speak with Mr. Coney? Okay, just let me know when he's ready. All right, is there anyone else that any of the jails need called out of turn? Okay. All right, so while I'm waiting on those sign-ins, we'll go ahead and start with our regular list. First up is Lakia Fulton. Okay.
She's here, present, Judge.
Thank you. All right, good morning, Ms. Fulton.
Good morning.
Ms. Fulton, you're before the court this morning on one charge of trespassing on property, not a structure or conveyance. I find probable cause. And Mr. Romero, what does she want to do?
Judge, after speaking with Ms. Fulton earlier today, she wishes to resolve this matter. We wanted to know if the state had the offer for it today.
Your Honor, the state's offer is an adjudication, time served with no return.
Okay.
Judge, I did explain to her as far as the state's offer and as far as the the order not returning to the place. She told me she understands and she will be abiding by that, and she wishes to accept the state's offer at this time, Judge.
All right, so, Ms. Fulton, I'm gonna ask you a few questions before we're done today. To begin, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you, and now you can put your hand down. And Ms. Fulton, do you understand everything that we've discussed here today?
Yes.
Is anyone forcing you to resolve this case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, I do not.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand that if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
All right. And Ms. Fulton, what plea do you wish to enter? Guilty or no contest?
No contest.
All right. I accept your plea and find that it's freely and voluntarily given. Your sentence will be an adjudication of guilt with time served, and there will be a no return order to the location, which is Saxon Wall in Pompano Beach. And you understand that?
Yes.
All right. Thank you very much, ma'am. Good luck to you. Next will be Jasmine Hightower.
Bonded, Judge?
All right. Brianna Washington.
North Broward?
Okay.
Are you done? Okay, come on. Right here.
Hi, Judge.
Good morning, Miss Washington.
Hi.
All right, Miss Washington, you are here this morning on one charge of trespassing on property, not a structure or conveyance. I find probable cause, And Mr. Miller, what would Ms. Washington like to do today?
Judge, I spoke to Ms. Washington this morning, and she indicated that she would like to resolve this case if the court is so inclined.
All right, does the state have an offer for Ms. Washington?
Yes, Your Honor. State's offers an adjudication, time served with no return.
Okay. All right, so Ms. Washington, their offer to you is an adjudication of guilt with time served and a no return to the family dollar that's at issue in this case. Do you understand that?
Yes,
Do you want to accept that offer today?
yes,
All right, I'm going to ask you a few questions before we're done. Will you please raise your right hand? Do you swear or affirm to tell the truth?
yes,
Thank you, and now you can put your hand down. And Ms. Washington, do you understand everything we've discussed so far this morning?
yes,
Is anyone forcing you to resolve this case?
no,
Are you under the influence of drugs or alcohol?
no,
Do you need any more time to speak with your attorney?
no,
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
yeah,
Have you ever
I
been
mean, yeah,
Okay, have you ever been treated for mental or emotional illness?
no,
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
yes,
All right, and Ms. Washington, what plea do you wish to enter, guilty or no contest?
no contest.
All right, I accept your plea and find that it's freely and voluntarily given. Once again, your sentence will be an adjudication with time served, and remember, there is a no return order to that family dollar. You understand that?
Yes,
All right, thank you very much, Ms. Washington. Good luck to you.
okay,
Your Honor, Maine Jail advises they're ready for Mr. Coney.
All right, great. Let's go over to Maine. Okay, let's go ahead and bring up Mr. Coney. And
He's a person, Judge.
are you here on Mr. Coney's case? Are you just here to observe or to speak? You don't have to, I'm just asking. Okay, you can come on up to the podium. All right. Good morning, Mr. Coney.
Good morning, ma'am.
Mr. Coney, you're before the court this morning on 2 charges. Count 1, possession of burglary tools with intent to use. Count 2 is burglary of an unoccupied conveyance unarmed. I find probable cause. Before I go to the parties, ma'am, you indicated that you want to speak today. Is that correct?
Yes, I can.
Okay, so I'm going to tell you some things that I say to everyone who comes to first appearances. Number 1, everything that we say here is being recorded and can be used against you and potentially him at a later date. Do you understand?
Yes, ma'am.
All right. Additionally, because this is just the first appearance hearing, I'm not addressing anything about the background or the facts of this case. We're only dealing with bond and release conditions today. Do you understand that? Okay. If you want to speak, then that's fine with me as long as it's just about those matters. I'll put you under oath, and I'm just going to ask you, if you do want to speak loudly into that microphone in front of you so that they can hear you, okay?
Okay.
All right. So you still want to speak?
Yes,
Okay. Will you please raise your right hand? Do you swear or affirm to tell the truth?
I do.
Thank you. And now you can put your hand down, and will you please state your full name and spell your last name for the record?
Yes, it's Shannon Wimberly.
Okay.
Last name is Wimberly.
All right. And Ms. Wimberly, what is it that you would like to tell us?
Well, I just basically wanted to say that he does have ties to the community. My father is a pastor at church. I'm the leader of the youth group. He agreed to work with the youth boys for the spring break.
Okay.
His mom is fighting cancer, so he assists with his mom. So that's what I wanted to say.
Daughter?
No.
Okay. Okay. All right. Okay. Is there anything else that you want to say? Okay. All right. So now I'm going to go to the attorneys. I'll hear their recommendations, then I'll make a decision, okay? All right.
Judge?
Yes.
The court having already found probable cause, as you heard, he has very strong ties to the community. He's 35 years old, been living in our community his whole entire life. He's a barber. He's been in that profession now for about 7 years. On a good week, he can make up to about $500 a week. Now, he lives with his parents here in Broward County. His parents and his fiance are the people that are going to help post his monetary bond. Now, Judge, count 2 is a third-degree felony. Normally, I'd be asking for a $1,000 bond. However, under the circumstances, because of his prior contacts with the criminal justice system, I'm asking double that amount. I'm asking for $2,000 on count 2 on Mr. Coney's behalf, Judge.
He's on federal probation right now?
Yes, begun on the 31st of October of last year. Additionally, he has charged would like me to go through.
Not at this time. Has anyone been in contact with his probation officer? Okay, I just want to know if anybody had spoken to them yet. All right, what's the state's recommendation?
Your Honor, the state's recommendation for count 1 to keep bond in place, and count 2, state's recommendation is $7,500 bond with no victim contact and no return.
Mr. Romero, regardless of whatever bond I decide to set today, I assume you're going to discuss with him what could potentially happen as to the probation issue.
I did.
All right. All right, the bond on count 1, I'll leave the standard bond in case. As for count 2, the bond is going to be set at $5,000. There will be orders of no return as well as no victim contact. Mr. Coney, so that you understand those orders, that means you're not to go to the location that is at issue in this case. With respect to the no victim contact order, whether you know the alleged victim or not, that means no being in the same place at the same time as this person, no phone calls or text messages to this person, and no social media contact or third-party contact with that person. Do you understand that?
Yes, ma'am, Your Honor.
All right, thank you very much. Good luck to you. Ms. Wimberly, thank you.
Thank you.
All right, see Mr. Plant is here, so we'll go to our MO cases now if we have them present. First up on page 9 is Terrence Hammond.
Thank you, Judge.
Thank you.
Judge, I've been advised Mr. Hammond is a medical reset.
Okay, thank you.
Thank you,
And
sir.
how about Timothy Duncan on page 10?
Maine.
He's approaching, Judge. He's here at me. Come on up, sir.
Good morning, Mr. Duncan.
Good morning, ma'am.
Mr. Duncan, you're before the court this morning on 2 charges. Count 1 is a misdemeanor capias. That is for a municipal ordinance violation relating to a charge for petty theft. 2 is for possession or use of drug paraphernalia. I find probable cause, and I will hear from the parties.
Judge, I speaking to Mr. Duncan earlier. He wishes to resolve this matter. We wanted to see if the state had a plea offer for him today.
Let me also ask, before I go to the state, I see on the MO case, which is for petty theft,
Yes, Your Honor.
is there an offer in that, or is there any issue with regard to restitution?
Judge, I'm reading the probable cause affidavit.
Judge,
There
as a
is
friend of
no-
the court, I believe Mr. Duncan advised me it was allegedly from Walmart in which they retrieved all their property.
Right.
They
So
did?
he can resolve,
Okay,
in other words, and there will be no restitution.
okay. I just wanted to
didn't-
know,
didn't
because that,
speak-
I see that that KPS had the higher bond, so I wanted to make sure there wasn't an issue before we went
It's a high
further.
one, 500.
All right, what's the offer on the city case?
It's the paraphernalia.
Your Honor, state's offer is an adjudication, time served.
Judge, Mr. Duncan would like to accept the state's offer, Judge.
All right,
As well as the city's offer, Your Honor.
same thing?
Yes, Your Honor.
Okay. All right, Mr. Duncan, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you, and now you can put your hand down. And Mr. Duncan, do you understand everything we've discussed so far this morning?
I do, ma'am.
All right, is anyone forcing you to resolve these cases?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak to your attorney?
I do not, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, I do, ma'am.
All right, have you ever been treated for mental or emotional illness?
No, ma'am.
Okay, and do you understand that if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
I understand, ma'am.
All right, and Mr. Duncan, what plea do you wish to enter? Guilty or no contest?
No country.
All right, I accept your plea and find that it is freely and voluntarily given. Your sentence in both cases will be an adjudication of guilt with time served. Good luck to you, sir.
Good luck, sir.
Good luck, sir.
All right. Next up on page 21 is Shane McGrath.
McGrath. Yes, state
McGrath is on page 21.
cases.
Judge, I haven't had an opportunity to speak to Mr. McGrath. Can we put him on recall?
That's fine. Just let me know when he's ready.
Thank you, Judge.
All right. So, Mr. Plant, that's your last
I'll
one.
recall them.
All right.
That was it?
That's it. On Mr. McGrath's case, if you're planning on sending that to division, you don't have to stay. Just let me know. Okay. All right. Next on my list is Stacy Grakowski. All right. Thank you. Good morning, Ms. Grakowski.
Good morning, ma'am.
Ms. Grakowski, you're before the court this morning on one charge of trespassing or failing to leave property upon order by owner. I find probable cause. And Mr. Miller, what are we doing in Ms. Grakowski's case?
She's interested in resolving this case if the court is so inclined.
Is there an offer?
Just a moment, Your Honor.
Okay.
Thank you. Your Honor, the state may have a concern about mental health in this case, possibly transferring the case to mental health court.
Have you ever had cases in Judge Lerner Wren's division?
Moment.
Mr. Miller, did you have a chance to speak with Ms. Grakowski?
I did, Judge. I didn't have any particular concerns, but
All right.
Your Honor, if she would like to resolve the state's offer as an adjudication, time served with no return, and no. Yeah, just a no return.
All right. Ms. Grakowski, if you would like to resolve this case today, the state's offer to you would be an adjudication of guilt with time served and a no return order to the location of the trespass. Do you understand that?
Yes, ma'am.
And do you want to resolve this case and accept that offer today?
Yes, I do, ma'am.
All right, I'm going to ask you a few questions. To begin, will you please raise your right hand? Do you swear or affirm to tell the truth?
Absolutely.
Thank you. And now you can put your hand down. And Ms. Grakowski, do you understand everything we've discussed so far this morning?
Absolutely.
All right. Is anyone forcing you to resolve this case?
No.
Okay. Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Don't need it.
All right. Have you ever been treated for mental or emotional illness?
Yes, ma'am.
Is there anything about that illness today that impacts your ability to accept this plea?
No.
All right. And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, I do.
All right. And Ms. Grakowski, what plea do you wish to enter, guilty or no contest?
100% guilty.
All right.
Ma'am.
I accept your plea and find that it is freely and voluntarily given. And Ms. Grakowski, once again, your sentence is going to be an adjudication of guilt with time served, and there is a no return order to that location. You understand that, ma'am?
Yes, ma'am.
All right. Thank you. Good luck to you. Ivy Davis.
Medical research, Your Honor.
All right. Thank you. Karen Foley Walton.
Yes.
All right, good morning, Ms. Foley Walton.
Good morning.
You are before the court this morning on 2 charges. Count 1 is possession of cocaine. Count 2 is a municipal ordinance violation for open container. I find probable cause, and I will hear from the parties.
I'll defer.
Is the state seeking anything besides the standard bond in this case?
No, Your Honor.
All right, Mr. Miller?
Judge, so I spoke with Ms. Foley Walton earlier. She advised me she lives in Orlando. She was down here visiting. She doesn't have the ability to bond herself out. She doesn't have any contacts that she can call. Apparently her phone was not with her when she was arrested. She does have a sister, however, who lives in Plantation that she believes she could reside with. The court would consider releasing her to pretrial upon verification that her sister will both lives here and will allow her to reside with her.
Mr. Goldsmith, does she have any prior criminal history?
Yes, Your Honor, she had priors at Orange County. She had from January 17th of this year, trespass. The trespass upon order by owner.
All right. Ms. Foley Walton, I would be willing to place you on pretrial supervision with 2 conditions. Number 1, pretrial would have to verify with your sister that you would be residing with her at the local address that Mr. Miller has advised me of. And number 2, you would be subjected to random drug and alcohol testing. Do you understand that?
Yes, but ma'am, I didn't have no coke.
I don't want you, no. I don't want you to say anything about the facts of the case.
Okay.
Okay, that's for another day.
A lot of money for me. I don't have that kind of money to
All
be
right,
paying.
so what I'm saying to you is that I will ROR you as long as pretrial can verify the address and that you would be subjected to the random drug and alcohol testing. You understand that?
Okay. Yeah, that's fine.
All right, so I just need you to understand, if they are unable to verify the address with your sister or unable to verify that you'll be residing there, then that bond will remain in place and you would likely come back up on my second look docket in a few days, okay?
Okay.
All right, so,
Sounds good.
all right, thank you very much.
Thank you, Judge.
Thank you.
Thank you, State. Let's for it first.
Ansley Warren.
She's at North Broward, Your
Yes.
Honor.
All right, good morning, Miss Warren.
Good morning.
Miss Warren, you're before the court this morning on 1 charge of possession of fentanyl. I find probable cause, and at this time, I will hear from the parties. Is the state seeking anything beyond the standard bond in this case?
No, Your Honor. Stay, keep on in place.
All right, Mr. Miller.
Judge, we're seeking pretrial release for Ms. Warren. I spoke to Ms. Warren's mother this morning. She was on her way to a cruise and is not going to deal with this until Monday. And so if we don't release her to pretrial, she'll be sitting until at least then. She, as the court is aware, she was in rehab. She came down here for whatever reason. She intends to return to her halfway house in Jupiter. I advised her that if the court were to grant our request and put her on pretrial release, she would probably be subject to random testing. Jupiter, I think, is in just north of the Palm Beach, Martin County line, so she's about an hour away. She won't be missing any court dates, and we're hoping that the court will grant our request.
I'm sorry. Miss Warren, are you definitely going to be going back to that halfway house in Jupiter?
Yes.
Have you already know that they have a spot open for you and you'll be residing there?
Yes.
All right. Does she have any prior state? All right. So, Miss Warren, I will place you on pretrial supervision with 2 conditions. Number 1, you will be subjected to random drug and alcohol testing. Number 2, pretrial is going to have to verify with the halfway house that you're going to be going there and that you'll be residing there. As long as they're able to verify that, then you'll be released. If they are not able to verify that, then the bond will remain in place. Do you understand?
Okay.
Miss Warren, is the halfway house that you're speaking of on Village Boulevard in Jupiter?
No, it's off of Winsong Way.
Winsong Way? Thank you.
All right. Thank you, Miss Warren. Good luck to you.
Thank you.
Corinne Chevalier. Thank you. All right. Good morning, Miss Chevalier.
Good morning.
You're before the court this morning on 1 charge of fleeing or attempting to elude law enforcement. I find probable cause, and I will hear from the parties.
Judge, at this time, I'm not gonna be requesting anything.
All right. Anything from the state?
No, Your Honors.
All right, I will leave the standard bond in place. Thank you. Christine Walsh.
I believe medical? Loan?
All right, we'll reset her. Thank you. Teresa Crane.
Medical loan?
All right. Tammy Lewis.
Yes, ma'am.
Broward?
Thank you. All right. Good morning, Miss Lewis.
Good morning.
Miss Lewis, you're before the court this morning on 7 charges. Count 1, grand theft auto. Count 2, possession of cocaine. Count 3 is a felony violation of probation with a no bond hold. Counts 4 and 5 are felony capiases, which have no bond holds. 6 is a felony warrant for violation of pretrial with a no bond hold, and 7 is a felony probation violation with a no bond hold. I find probable cause. In light of Miss Lewis's no bond holds, do the parties wish to be heard on counts 1 and 2?
No, Judge, I spoke with the defendant. She's aware of the situation. She's going to have to deal with this in division.
Okay.
No, Your
All
Honor.
right, so I will leave those standard bonds in place, and Miss Lewis, you'll likely be seeing your division judge next week to address the violations of probation. Good luck to you, ma'am.
Thank you.
Gino Dimitro.
He's approaching, Judge.
Thank you. Good morning, Mr. Dimitro.
Good morning.
Mr. Dimitro, you're before the court this morning on an ad charge. This is for an out-of-state felony hold out of the state of Illinois. I find probable cause. And Mr. Dimitro, since this has a no bond hold on it, that means you'll go before the extradition judge to determine how it's going to be handled. That will likely be on Tuesday of next week. All right, good luck to you. Yes? What's the matter?
His other charges of Palm Beach County.
Yes?
So you advise him he's going to go to Palm Beach County?
He's going to Palm Beach County. Okay, confinement. Confinement's telling me since the other holds he has are Palm Beach, he'll be going to Palm Beach first and then to Illinois after that. Okay? All right. Good luck to you, sir. Akeem Breedlove.
I'm told that Mr. Breedlove is in court this morning.
Okay, these are ad charges, correct?
Right.
All right. Okay, we'll reset him. Jairo Sanchez.
Medical reset?
All right. Did I already? In his case, I'm gonna go ahead and make a probable cause finding and we'll reset him for bond.
Oh, is that him?
I don't think so. Louis Apuzzo. I think that's
Hey,
Mr.
Jeff.
Apuzzo. All right, good morning, Mr. Apuzzo.
Bond an hour.
He's here, present, Judge.
Thank you. Mr. Apuzzo, you're before the court this morning on a misdemeanor capias. This is related to a charge for battery. I find probable cause, and I do see that you are set to go in front of your division judge on Monday for a status hearing. Do the parties wish to be heard any further?
Judge, when was the when was the failure to appear from?
Hold on, let me just take a look.
Thank you, Judge.
This is, the capias was issued February 10th, 2020.
Judge, my understanding, speaking with Mr. Apuzzo, from what he advised me, he was in custody in Palm Beach on a misdemeanor offense. So he's saying he didn't willfully miss court. He's asking if the court would consider releasing him on this offense.
Because then I have a failure to appear on Monday in Palm Beach. I did 12 days for this offense too.
Are we able to confirm that he was in custody on February 10th? No one's able to verify? All right, what I'm being told is that there's no way for us to verify that he was in custody in Palm Beach County on that date. So if I can't verify that,
It's ROR.
Well, Judge, he does have documentation from what he's advised me, showing that, and I'm gonna tell you exactly what it says. It's a notice of arraignment set for March 9th, so it does show that he was given this notice on March 5th. He advised me that he'd been in custody for over 20-something days, which, if I do the math correctly, would have included the date that the court mentioned that he missed court, but it doesn't say specifically that he was in custody or anything like that. I'm just telling you, it's basically a notice to appear showing that he was given notice on March 5th. But he
Right.
advised me he was in custody.
but he received that notice to appear on March 5th, but that doesn't relate back to anything before that, right?
No, not with this documentation.
I'm sorry, what was that? February, well, they're saying that, he's saying he was in custody on February 10th. That's when this capias was issued.
Yeah, according to Palm Beach, he was incarcerated in Palm Beach on February 7th.
Okay, confinement's telling me she has something from Palm Beach saying he was incarcerated on February 7th. That's fine. Okay.
I did 12
All right,
days for this.
so
battery
Mr.
work.
Apuzzo, I'm going to ROR you on this, but I need you to understand very clearly what I'm about to say to you. Because this is an active case since a capias has been filed. Just because you're gonna be released today, that doesn't mean the case ends, so there will be future court dates. So please make sure the clerk's office has the correct address for you so that you know about any future court dates you have to be present for. Because if you miss those court dates, then this is what happens. You understand?
Yes.
Okay, all right. Thank you very much, sir. Good luck.
Your Honor, the state would be requesting no victim contact.
Well, I mean, this is a capias. I'm sure that's already happened, but in an abundance of caution, I'll say it for the record, there's a no victim contact order. So, Mr. Apuzzo, that means with respect to whoever the alleged victim in this case is, no contact with that person. No being in the same place at the same time, no phone calls, text messages, social media contact, or third-party contact. Do you understand?
Yes.
All right, thank you. All right, I have a sign-in on page 16 for Timothy Fullwood. Mr. Smallman is present in the courtroom on his behalf.
Mr. Fullwood, come on up, please.
On behalf of the state.
Mr. Smallman, your private attorney.
All right, good morning, Mr. Fullwood.
Good morning, Judge.
Mr. Fullwood, you're before the court this morning on an ad charge. This ad charge is for first-degree premeditated murder. I find probable cause for this charge. As you can see, your private counsel, Mr. Smallman, is present with me in the courtroom. At this time, I will hear from the parties, and ladies, I'm just gonna ask you to speak into that microphone, because I know when you stand, it's hard for them to hear at the jail.
Your Honor, I'm gonna just speak into the record the priors regarding the state's
I can't hear
recommendation.
you. Can one of the deputies turn the speaker off at the jail? I cannot hear. Thank you.
Judges, the state is requesting a no bond hold on this defendant. I'm gonna read into the record the prior criminal history.
All right.
Most recently, out of Miami-Dade County, the defendant was convicted from a 2011 arrest of homicide, manslaughter, culpable negligence. He was released on that charge from DOC custody on October 16th of 2019. The incident on this particular case, February 1st, 2020, qualifies him as a prison releasee reoffender, which means that there's a min-man of life due to his designation. Additionally, there was a 2011 arrest and conviction for armed burglary where he was convicted on that same case. Out of Manatee County, there was a battery on a detention facility from 2002 conviction, two counts of battery on a detention facility from 2002 where he was convicted. Here in Broward County, he has a robbery by sudden snatching from 2006 that he was convicted of, in addition to a misdemeanor battery. There was also possession of cocaine with intent to distribute from 2010, conviction from 2010, along with convictions of possession of cocaine from 2010, a misdemeanor possession of cannabis, and most recently this particular case. He does also qualify due to his designation for habitual felony offender and habitual violent felony offender. So due to his designations and his prior criminal history, he does pose a risk to the community if released. In addition to the facts of the case, the victim was threatened prior to, which is why the state has submitted it in the first-degree murder of premeditation. He was threatened. He recklessly shot into a vehicle with disregard for human life of the victim and disregard for human life of others around. Based on that, his flight risk indicated by the facts of this case, when police intended to initially apprehend him, he attempted to flee and was successful in doing so. We do believe that based on what he's facing, the maximum charges, in addition to his actions in this particular case, that he is a flight risk, a danger to the community, and for those reasons, he should be held no bond.
Seeking a finding of proof and presumption great as a basis for that?
Yes, Your Honor.
And Judge, to just give you some procedural history, he had been magistrated on an attempted first-degree murder. The victim has since died, and the medical examiner found that it was due to the gunshot wound from these events. So that's why it's an ad charge.
Okay.
Thank you.
Thank you. All right, Mr. Smallman, your response, please.
Sure, a couple procedural things. First, it looks like there's a change of charge and an add charge. And so I want to get that cleared up, because if you were to issue some sort of bond, that's certainly going to be an obstacle.
Right.
It looks like count 7 is a premeditated murder, and count 1 is a change of charge from attempt to first-degree murder. It's one or the other, I'm guessing.
Judge, what happened was when the detective dropped the PC at the jail,
Yes.
it wasn't stamped ad charge. Our office is already on top of it, contacting the jail to sort this out.
Okay, so there's not going to be a duplicative issue.
No, and when you go into, I went into BSO picks this morning, they added it.
Okay.
So you see the other counts, and then at the bottom it says murder premeditation, no bond. So.
Okay.
That doesn't exactly clear it up.
Well, let's address the bond issue
Okay.
first, and we'll come back to
So,
it.
all right, so addressing the bond issue, as the state said, he was previously magistrated on the attempted first degree. A bond was given. He was given a bond in the amount, I think, without breaking it down, the total was about $350,000. I'm sure someone can correct me if I'm wrong.
I had it at $275,000.
Okay.
Okay, give or take, it's a lot of money, with all sorts of pretrial conditions, as you can imagine. I'm not sure if you were the one who magistrated him. Okay, so that being said, I understand there's a change in legal circumstance, okay, with someone passing away, and that's obviously unfortunate. However, the actions haven't changed that you're magistrating him on. You've done this before, and you've read it's the same PC. it does change things as far as the charge. But your concern on your analysis of why you gave the bond that you gave initially, and by the way, we had a subsequent bond motion in front of the division judge to reduce that bond, which he denied, but did not raise the bond when asked either. I'm not sure procedurally if he was allowed to do that then or not, but regardless, you've seen the facts of this case and those haven't changed. And so while it's unfortunate that we have a victim who's passed away, I don't think that your analysis of bond, safety of the community, ties to the community, facts of this case, none of that has changed at all. And so it's our position that the bond shouldn't change at all. It should still be whatever it was. If the state's right, then $275. If I'm right, then $350. I'm not trying to make the argument for a higher bond. Whatever it was, with all of the pretrial conditions that Your Honor saw fit when you did your analysis the first time.
Okay. I would like for someone to confirm this for me because I do remember Mr. Fullwood's first appearance hearing, and there was a very specific reason that I did not find proof evident presumption great at that time and gave him a bond. Based on my recollection, I believe the probable cause affidavit that we have today includes some additional information that was not included at his first appearance hearing. Is that correct?
Well, it definitely includes some additional facts, Judge. I was not present for the hearing Mr. Linder was, so I can't speak directly, but obviously.
Well, is someone able to pull up the probable cause affidavit that was used? And yes. If you have it, I'd like to see it because there's a specific detail that I will advise you of in a moment.
Okay. I obviously was not present for that hearing.
I understand. Okay. All right. Okay. At the time of Mr. Fullwood's first appearance hearing, I declined to make a finding of proof evident presumption great because at that time, there was very limited information provided in the probable cause affidavit regarding identification of the vehicle that was involved in the shooting. In the probable cause affidavit that I have before me today, it includes some additional information, including a statement that was made by the victim to detectives on February 4th, in which the victim confirmed that the suspect vehicle involved in the shooting was the same vehicle that was present at the gas station. Additionally, I have noted some statements that are in the probable cause affidavit provided by Cassandra Foster, which provides some information regarding the vehicle, who that vehicle was rented through, and the information provided pertaining to that. She additionally provided some statements to law enforcement concerning information provided to her by Mr. Fullwood, requesting that she erase certain telephone calls and report that vehicle stolen, all of that having taken place at about the same time as the incident that's alleged to have occurred in this case. Based on the additional information that has been provided in the probable cause affidavit that is before me today, at this time, the court is going to make a preliminary finding of proof evident presumption great and order that Mr. Fullwood be held no bond on this charge. That will be without prejudice, for him to have the appropriate Arthur hearing before his division judge, should that be necessary to further address those issues.
Thank you, Judge.
Thank you.
Thank you for listening, Judge.
Thank you, Mr. Smallman. Good luck to everyone. Mr. Fullwood, good luck to you, sir.
Judge, North Broward is asking if Mr. Gator can be taken out of turn. Okay, go. We're gonna go talk to the judge now, Mr. Gator. Mr. Gator. I'm sorry, that's page.
And Judge, whenever the court's ready, we're ready to proceed on Mr. Shane McGrath. I know that was on recall.
Gator's on page,
Yeah, I'm gonna take him after this one. Gator, Gerard Gator.
page 17, Judge.
I got him. All right, we'll do him and then we'll go to Mr. McGrath after that.
Thank you, Judge.
Is that like Gator?
All right, good morning, Mr. Gator. All right, you're before the court this morning on 2 charges. Count 1, resisting an officer obstructing with violence. Count 2 is criminal mischief, $200 or less. I find probable cause, and I will hear from the parties. State, we'll begin with you.
United States recommendation
Okay.
is a $1,500 bond.
I'm sorry, I can't hear you. You gotta speak into the microphone.
The state's recommendation is $1,500 bond.
All right.
Judge, we're not going to object to the bond amount. We're requesting a medical, psychiatric, and a photo order.
All right, that's fine. I will sign those orders, and the bond on count 1 will be set at $1,500. All right, thank you, Mr. Gator. Good luck to you.
Fucking
All
Jones.
right, now we'll go back to Maine. Okay,
He's approaching, Judge.
where did Mr. Plant go? Did he just leave? It's fine.
To put on recall for Mr. Plant.
I'm not sure where he went. I don't know if he just stepped out. He was just here. Hold on one second. Let me just see if he just stepped outside the door. Not there. Okay. All right. Give me a few minutes for Mr. McGrath. So Mr. Plant said he wants to be present, so just, we'll recall him in a moment. If he comes back in, don't let him go anywhere. All right. Next up is Donald Williams.
He's approaching, Judge. You see our man? Come on
Thank
up,
you.
sir.
Good morning, Mr. Williams.
Morning.
Mr. Williams, you're before the court this morning on 3 charges. Count 1, driving while license suspended. 2 and 3 are misdemeanor capiases, which are also related to driving with a suspended license. I find probable cause, and I will hear from the parties.
Judge, in speaking to Mr. Williams, first, I do understand in reference to count 2 and 3, they're a similar offense as count 1, and those are failure to appear in court. But after speaking to Mr. Williams, my understanding, Judge, from what he advised me, he never, I believe he advised me he never got court dates. He was unaware. He did tell me that he's taking active steps in trying to straighten out his driver's license. Judge, Mr. Williams, he's 6 years old. He has health issues. He lives here in our community, specifically in Miami, with his sister. His sister's not going to be able to afford to post a monetary bond. Considering these are all nonviolent, I'm asking if the court would consider releasing him on pretrial release under supervision.
Where does he live, Mr. Romero?
Let the judge know your address in Miami.
1770 Northwest 110 Terrace, Miami, Florida 33167.
Okay. All right. Any objection from the state?
No objection, Your Honor.
All right, based on the nature of the offenses as well as the age of the 2 capiases that are in this case, I will ROR Mr. Williams and release him to pretrial supervision. Mr. Williams, I just need you to listen to some information I'm going to give you. Mr. Romero has handed you a piece of paper there. Make sure that you read that after today's hearing. Though you're going to be released today, you will have to report in person to pretrial supervision. Because today is Friday, that will have to happen by Monday. If you fail to report to pretrial, as I have instructed you, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, ma'am.
All right. Thank you very much and good luck to you. Stephen Shepard.
Stephen Shepard, he's approaching, Judge, he's here at me.
Thank you. Good morning, Mr. Shepard. You're before the court this morning on 3 charges. Count 1, DUI with damage to property or person of another. Count 2, DUI with blood alcohol level greater than 0.15. Count 3 is having an open container in a vehicle that is not for magistrate. I find probable cause, and I will hear from the parties.
Judge, unfortunately, Mr. Shepard has no one to contact right now that can post his monetary bond. He's working here, he lives here, he's 55 years old, been living in our community for the past 40 years. He lives in Hollywood with his wife. Right now, his wife is out of town, so he can't get in touch with her. So, Judge, he's a registered voter here in Broward County. I'm asking if the court would consider releasing him on pretrial release.
State.
No objection, Your Honor.
All right, I'm willing to put him on pretrial, but it will be with random drug and alcohol testing. Mr. Shepard, a couple of things for you to know. Number 1, as I just said, one of the conditions of your release will be that you will be subjected to random drug and alcohol testing. That means no alcohol, no intoxicants until further order of the court. Do you understand?
Yes, ma'am.
All right. Additionally, Mr. Romero is going to give you a piece of paper there with some very important information on it that you'll need to read after we're done today. Though you're going to be released today, you will need to report to pretrial supervision in person by Monday. If you fail to report to them, as I've instructed you, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right. Thank you very much. Good luck to you, sir. Willie Williams. All right. Good morning, Mr. Williams.
How you doing, ma'am?
I'm well, thank you. Mr. Williams, you're before the court this morning on 1 charge of trespassing on an unoccupied structure or conveyance. I find probable cause. And Mr. Romero, what would Mr. Williams like to do today?
Judge, after speaking to him, he wishes to resolve this matter. He wanted to see if the state had a plea offer for him today.
All right. Yeah. It's on pretrial for a felony case?
Judge, in that case, I wouldn't, it would be against my advice as far as resolving this matter today.
Okay, let me just let you know, Mr. Romero, what I've just been advised by confinement is that they were advised, since he is out on pretrial on a felony case, that it appears, I don't know if a warrant has been signed by his division judge yet, but they're in the process of doing that, just so that. Okay, pretrial is telling me the warrant was signed, but there's a correction that's needed to it, so he needs to know that that's in the process of happening.
Let me let him know. One moment, Judge.
Okay.
Judge, I explained to Mr. Williams, nothing from the defense at this time.
All right. And just so that you know, pretrial's advised me the warrant was done on the 21st of this month, so this isn't what triggered it. It was done already. All right. So I'm going to leave the $25 bond in place, and there will be a no return order. Mr. Williams, a no return order means that you're not to return to this location. Do you understand that, sir?
now.
All right, thank you. Good luck. All right, now that Mr. Plant is here, let's call up Mr. Shane McGrath.
Page
He
21,
is a
Your Honor.
person, Judge. Mr. Plant's the man on the move, Judge.
I know, he's got places to be.
No, I finished, so.
All right,
all
good
the time
morning, Mr. McGrath.
wants.
Good morning.
Mr. McGrath, you're before the court this morning on 4 charges. Count 1 is trafficking methamphetamine between 14 and 28 grams. Count 2, possession of alprazolam. Count 3, possession or use of drug paraphernalia. Count 4 is a misdemeanor capias related to a municipal ordinance violation for possession of paraphernalia. I find probable cause for these charges, and I will hear from the parties at this time.
Judge, in reference to estate offenses, I did talk to Mr. McGrath, told him what he was arrested for. I did advise him the standard bonds that are in place currently. I believe that's $51,100. And speaking of Mr. McGrath, there's no way he's going to be able to afford to post that monetary bond, especially considering the fact from what he advised me, he lost his job approximately 3 weeks ago. He was working for a company called Patriot Moving Broker. He was employed there for about 3 years. Things were going well. He was making with commission about $1,000 a week, but unfortunately, since he's lost his job, right now financially he's kind of been a little bit strapped. He's looking for employment. He lives in Delray Beach, where he's renting a room. That rent is approximately $800 a month. So, Judge, as you can see, his financial resources right now are very, very limited. I'm going to be acting on count 1 if the court would consider reducing the bond from $50,000 to $5,000. I know that's a substantial decrease, but $50,000 is something impossible for Mr. McGrath.
All right, let's hear from the state.
The state would recommend keeping the bond in place on all counts.
Does he have any prior history?
Fraud in 2010 out of Utah. He stolen property out of Utah.
Till 2010? Nothing in South Florida? Well, I guess besides the 2019 municipal ordinance violation. All right. I'm not willing to reduce count 1 to 5,000. I am willing to reduce it to 10,000 if Mr. McGrath is willing to be placed on pretrial supervision and subjected to random drug and alcohol testing.
Judge, he advised me he wants to resolve my case since it's predating. Clearly, it's not as grave as the other ones.
Judge, he appreciates the offer. You'll accept that, Judge, at this time.
Okay, additionally, with respect to count 4, which is the municipal ordinance case, Mr. Plant is telling me that if he wants to resolve that case, that the city can make an offer if that's something he's interested in. What's the offer?
He said he wanted to just adjudicate time served.
Okay, that would be an adjudication time served on that count.
Or he can just go to court Monday.
The attorney is Mr. Plant right there on that count, so let him know what you want to do.
I would like to take that offer.
Okay, All right. So, Mr. McGrath, just to recap everything we're gonna do, and I'll have some questions for you in just a moment. As far as counts 1, 2, and 3 go, the bond on count 1 is going to be reduced to $10,000. And if you post the monetary bond on those counts, you'll be placed on pretrial supervision and subjected to random drug and alcohol testing. Do you understand that?
Yes, ma'am.
All right. As to count 4, which is the municipal ordinance violation case, the offer is an adjudication time served. Do you wish to accept that offer on that particular matter?
Yes, ma'am.
All right. Will you please raise your right hand? Do you swear or affirm to tell the truth?
I swear.
Thank you. And now you can put your hand down. And Mr. McGrath, do you understand everything we've discussed here this morning?
Yes, ma'am.
Is anyone forcing you to resolve this municipal ordinance matter?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
I do not.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
And Mr. McGrath, what plea do you wish to enter, guilty or no contest?
Judge, one moment, I just realized something.
Okay,
One moment.
go ahead. It is not.
Judge, may I have a moment to speak with Mr. Plant?
Not a problem. No, it's fine. I'll give you guys a minute. We're getting done with Mr. McGrath. I'm not moving on from him yet.
Judge, we're not gonna, have to do the plea, the colloquy.
He's not gonna go forward with the plea now?
No, he's not.
All
He
right.
hasn't had any, I mean, it was I wanted to see if he could post the bond or not, and, doesn't look like he's able to. It would have it's too much of a risk with his felony case. It's not really,
Okay, so I'm gonna leave the bond in place on that, and I'll include the MO case with his pretrial with the other case.
if he doesn't,
All right, so that one will just be placed on the same conditions.
it's better if he does not resolve.
Okay, that's
But
fine.
we'll talk, now he has appointed attorney, so we'll see him Monday or Tuesday.
Yes. Yes, I'm gonna leave the bond in place on count 4, and it'll be, if he does post it, it'll be pretrial with random testing. Just so Mr. McGrath knows, he has a status hearing on Monday morning with the division judge, all right? Good luck to you, sir.
Good luck, sir. Thank you, sir.
Do you need a phone order?
I'll sign the phone order. That's fine. All right, Mr. Plant, I'm releasing you till this afternoon.
Yes, Judge.
All right, next up will be Antonio Weston.
No problem.
Thank you. All right, good morning, Mr. Weston.
Good.
Mr. Weston, you're before the court this morning on 2 misdemeanor capiases. These are related to charges for trespassing. I find probable cause. And Mr. Miller, correct me if I'm wrong, but wasn't Mr. Weston with us recently?
Look, Judge. Your Honor, I'm showing he was arrested twice in January. January 13th for Acapius. Not this case, but the same charge. And on January 31st for trespass, one of them was this case. No, I take that back, not this case.
Okay.
And those were all resolved. He was sentenced.
Okay.
Looks like he was sentenced to about 10 days.
When?
February, no, never mind, March, February 5th, sorry, February.
So he has been out for a month, Your Honor. I'd like an opportunity to look and see if these K pieces were issued when he was in custody.
That's what my next question was going to be, actually. Are you able to tell me, looking at whether he was in custody? One of them is February 26th and the other is February 5th. Yes.
Right now, he was in custody. He was released on February 5th and arrested on January 31st, the most recent time. So at least one of those K pieces would have issued when he was in custody, or could have issued when he was in custody. And the January 13th, he got out January 14th.
All right, so that's one, but not the other.
In any case, I did speak to him this morning. He is interested in resolving these charges if the court is so inclined.
All right. Does the state have an offer for Mr. Weston?
Yes, Your Honor. The state's offer is an adjudication, time served, and no return.
All right.
In both cases.
All right, Mr. Weston, if you want to resolve these two cases today, the state's offer is an adjudication of guilt with time served and a no return order to the locations of the trespass. Do you understand that?
Yes.
Do you wish to accept that offer today?
Yes, ma'am.
All right, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you, and now you can put your hand down. And Mr. Weston, do you understand everything we've discussed so far this morning?
Yes.
Is anyone forcing you to resolve these cases?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
And Mr. Weston, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. Your sentence will be an adjudication of guilt with time served, and once again, there will be the no return order that we discussed. Do you understand that?
Yes.
All right, thank you very much, sir. Good luck to you. Valerie Cephalin.
Main judge.
Okay,
Case approaching, Judge. Maine.
thank you. All right.
Good morning.
Good morning, Mr. Cephalin. You're before the court this morning on one charge of DUI, alcohol or drugs, second offense. I find probable cause, and I will hear from the parties.
Judge, at this time, nothing to add. I'm just going to be requesting a property order.
All right, anything from the state?
No, Your Honor.
Okay, I'll leave the $1,000 bond in place, and I will sign the property order. Thank you. Good luck, sir. Nicholas Ruiz.
Come on up, sir. He's approaching, Judge.
Thank you. Good morning, Mr. Ruiz. You're
morning,
before the court this morning on a misdemeanor capias. This is related to a charge for possession of a controlled substance without a prescription. I find probable cause, and I'll hear from the parties.
Judge, Mr. Ruiz advised me he didn't willfully miss court. He never got noticed. My understanding is, I believe the facts are concerning he didn't have his his prescription on him for his blood pressure medication. I'm almost positive, Judge, once he goes ahead and presents that prescription through his attorney to the state, most likely this case is going to be dropped. So, Judge, I'm asking at this time if the court on this misdemeanor offense would release Mr. Ruiz ROR. I'll give him instructions to contact the clerk's office. I believe he signed up with the PD's office, so to make sure this doesn't happen again as far as failing to miss court.
State. While they're checking that, I'm just gonna say, Mr. Romero, you can discuss this more with him, but the address that I'm showing for him is in Orlando. And if he doesn't reside in Orlando, which seems to be the case based on these circumstances, he needs to make sure the clerk's office has an updated address so he's getting notice of his court dates.
There's no objection from the state with regard to ROR.
Okay. All right, Mr. Ruiz, I'm going to ROR you, which means that you'll be released today. Please understand, Mr. Romero is going to give you some information to read after today's hearing. Though you're going to be released today, that doesn't mean that the case is ending. There will likely be another court date that's set. So as I said before, it's going to be your responsibility to make sure the clerk's office has a proper mailing address for you so that you're getting notice of your court dates. Because if you fail to appear for your court hearings, then a capias can be issued and you can be arrested. Do you understand that?
Yes, ma'am.
All right. Thank you very much, sir. Good luck to you. Ricardo Altez.
He's approaching, Judge.
Okay. All right. Good morning, Mr. Altez.
Good morning.
You're before the court this morning on 8 charges. Count 1, DUI, alcohol or drugs. Count 2, DUI with damage to property or person of another. Count 3, DUI with damage to property or person of another. Count 4, DUI with blood alcohol content greater than 0.15. Count 5, violating restrictions placed on a driver's license. Count 6, careless driving. 7, failure to provide proof of insurance. 8, failure to display vehicle registration. Counts 6, 7, and 8 are not for magistrate. I find probable cause, and I will hear from the parties.
Judge, my understanding is Mr. Altis has a clean record. He's 45 years old, been living here in South Florida now for the past 4 years. He works for a local dealership in sales. He's been doing that for about 1 year. He lives in Margate with his wife and his sister. Right now, him and his wife are helping out his sister. So she's not working. She's looking for work. His wife does work. She's a caretaker. They've been living in that Margate address for the past 2 years. From what he informed, after paying rent and everything like that, his wife really doesn't financially have the money to post a monetary bond. So, Judge, we're asking if the court would consider releasing him on pretrial release.
State,
Our state would recommend keeping bond in place.
does he have any priors? Under normal circumstances where someone has a relatively clean record, as Mr. Altez does in this case, I wouldn't ordinarily have an issue with placing them on pretrial supervision. My concern in this case is that the allegations include a crash with damage to another person's vehicle and potential injuries, and the breath test results are over 3 times the legal limit.
Judge, based on that, besides standard pretrial, would the court be inclined to pose additional restrictions such as no alcohol or intoxicants and having Mr. Altez subject to random testing?
Well, even with the additional restrictions, I'm not willing to give him an ROR to pretrial. There will have to be some sort of monetary bond. What I would be willing to do is give him an ROR on count 3. That would reduce the bond by $1,000. But I would still put him on pretrial with random testing if that's going to be the case.
Judge, another of the problems is, and he appreciates the court trying to help him out and work with him. However, the problem is when he was arrested, he didn't have his phone with him, and he unfortunately doesn't have the phone numbers of his wife or sister memorized, and they do not know he's here, so they don't even know to try and help him out or they don't even know where he is right now. That's the problem.
Okay. Well, I mean, if he's placed on pretrial with the random testing, if I reduce the bond by somewhat, I'm not going to give him the RR. I can tell you that's not going to happen. But if he's going to be put on pretrial supervision, he can let pretrial know whatever the address is, and I'm sure someone can get in contact with them if that's going to be the case.
Judge, I don't think pretrial is going to talk to him until he actually posts the bond. And if it's just standard pretrial, they're not going to go in. I don't think they are. Pretrial can correct me.
I can ask them. But the issue is, does that not get triggered until the bond is posted? All right. All right, here's what I will do. Either he will have the monetary bonds as they're set, or it will be pretrial supervision, pending verification of the address, with random drug and alcohol testing and a TAD monitor.
Thank you.
Say pending verification.
Let the judge know what you want to do, sir.
I don't want no monitor.
What do you want to do, Mr. Altez?
So, the police got my phone. They got my phone. My phone got all my number on it. I want to
Mr.
call
Altez,
somebody to bring it.
I'm giving you a choice. It's either the monetary bonds that are in place, or you can be placed on pretrial supervision with the TAB monitor and random drug and alcohol testing. So it's one or the other. What is it that you want to do?
Okay, I do it.
All right, so it's going to be pretrial supervision with a tab monitor and random testing. Pretrial will verify all the information and they will let him know what's going on, okay?
Okay.
All right, thank you. The bonds are staying until that's taken care of. It's pending, because if you're verifying all the information, then it's an RR. Okay. Jeremy Gassett.
NHL, Your Honor.
Mr. Gass is approaching, Judge.
Thank you. Good morning, Mr. Gassett.
Good morning.
You're before the court this morning on one charge of second-degree petty theft. I find probable cause, and I will hear from the parties.
Judge, it's me, Mr. Gassett. He wishes to resolve this matter today.
Is there an offer from the
In the
state?
middle of
Your Honor,
the
he has
podium.
pending case.
Is it pertaining to this case?
I'm sorry? Okay, I can't hear. What? Say that again?
He has a pending, possession of firearm and equipment.
He has a pending possession of a firearm case?
Yes, Your Honor.
May I have a moment to consult with Mr. Romero?
Go ahead.
Thank you.
Plus he has other firearms.
Go ahead, Mr. Miller.
Judge, Mr. Gassett and Mr. Hunter, who's on the next page, their probable cause affidavits are identical. They were arrested 22 minutes apart, but the write-up is exactly the same. It's cut and paste. But the law enforcement officer who filled these out did not indicate that these two gentlemen were co-defendants, that they were co-arrestees, or that it related to each other in any way. So either something is amiss, and I'm asking the court to look at these with a critical eye. Because if they're not putting the fact that these two gentlemen were co-defendants, then the probable cause affidavit is faulty and not reliable. And if they're not co-defendants, then they're cutting and pasting the write-ups, and again, the probable cause affidavit lacks reliability. And so I'm asking the court to find no probable cause based on the fact that these probable cause affidavits, in one way or another, are faulty.
State.
One moment, Your Honor. Your Honor, state would be asking for time to perfect.
All right, I'm going to grant the state 24 hours to perfect. This will be continued for 24 hours, so it'll be reset to tomorrow.
Thank you, Judge.
Thank you. assume we're gonna have the same issue on Mr. Hunter, so if you wanna go ahead and call Mr. Hunter up, Mr. Romero will
Mr.
go
Hunter,
ahead
come
and
on up, please.
address the same issue.
He's approaching, Judge.
Thank you. All right, good morning, Mr. Hunter. You're before the court this morning on one charge of second-degree petty theft. I understand we're going to have the same issue in this case that we had in the prior case. Is the state making the same request?
Yes, Your Honor.
All right, in Mr. Hunter's case, go ahead, Mr. Romero.
Judge, in Mr. Hunter's case, we're in a little bit of a different position. My understanding, Mr. Hunter's now not out on any sort of case. He doesn't have the $25, so I'm asking if the court would consider an ROR under these unusual circumstances.
State.
Your Honor, the state would recommend keeping bond in place due to prior criminal history. In 2000, well, hold on, Your Honor. Your Honor, in 2018, DWLS, in 2017, unlawful use of false name identity, 2015, utter forged instrument, 2010, resisting without violence, 2007, unlawful use of a false name, 2004, sell or deliver cocaine. Also 2004, sell, deliver cocaine. 2004, burglary, conveyance unoccupied.
He has a warrant out of Georgia that's
Judge, if I've been hearing correctly, the last time he's had contact about was 2 years ago. Now, I'm not saying that this should automatically disappear or the state can't go forward with this. The state certainly has their own prerogative if they wanted to pick it up. I'm just asking, considering these unusual circumstances, this is a nonviolent offense. He's been clean for about 2 years, and I believe 2 years ago his contact were nonviolent offenses. That's why I'm asking under these unusual circumstances for an ROR on Mr. Hunter's behalf.
Okay, let me just confirm one other thing. The warrant that's out of Georgia, when was that issued? Okay. All right, in Mr. Hunter's case, I'm gonna make a probable cause finding and I will grant an ROR. Mr. Hunter, please understand that though you're going to be released today, that does not necessarily mean that's the end of the case, which means it will be your responsibility to be in contact with your attorneys and the clerk's office so that you know about any future court dates you need to be present for. Do you understand that, sir?
Yes, ma'am.
Thank you. Thank you. Jean-Pierre Ginty?
He's approaching, Judge.
Thank you. Good morning, Mr. Ginty.
Good morning.
You're before the court this morning on 2 charges. Count 1, DUI, alcohol or drugs. Count 2, operating without a valid driver's license. I find probable cause, and I will hear from the parties.
Nothing to add from the defense, Judge.
All right, anything from the state?
No, Your Honor.
Okay, I'll leave the bond in place as it is. Good luck to you, sir.
I'll call your mom.
Alonzo Lewis?
Yes. Where's that? Oh, Judge, I've been advised he's in court, 6160, so reset for tomorrow.
That's fine. We'll reset it. Pedrito Gonzalez?
Come on up, sir. He's approaching, Judge.
Thank you. All right, good morning, Mr. Gonzalez.
Good morning, ma'am.
Mr. Gonzalez, you're before the court this morning on 2 charges. Count 1, second-degree petty theft, third or subsequent offense. Count 2 is possession or use of drug paraphernalia. I find probable cause, and I will hear from the parties.
Nothing to add at this time, Judge.
All right, I will leave the bonds in place. Thank you. Devontae Watson.
Mr. Watson, come on up, please.
Okay. Good morning, Mr. Watson.
Hey, how you doing?
I'm well, thank you. Mr. Watson, you're before the court this morning on 3 charges. Count 1, grand theft of a firearm. Count 2, carrying a concealed firearm. Count 3, possession of cannabis 20 grams or less. And Mr. Miller, I will hear your argument at this time.
Judge, grand theft of a firearm, there's no indication that Mr. Watson knew or should have known that the firearm was stolen. In fact, he told the police that he bought it from a pawn shop. And so there's just no nexus between the stolen gun and him possessing it. So I'd argue there's no probable cause to hold him on that charge.
State your response.
Just a moment, Your Honor. Your Honor, the state would just respond by arguing that when the defendant was pulled over and he was speaking with the officer in the case, and the officer asked him if he knew that there was anything illegal inside of the vehicle, then the defendant then responded that he had a firearm under the seat. State would recommend that there's probable cause and to keep bond in place.
Oh, may I respond, Your Honor? So perhaps, that's quite a reach. The fact that he's advising the law enforcement that there's a firearm in the vehicle, but the fact that it's concealed, which is what he's charged with, may be what he was responding to. But to try to say that he knew that the gun was stolen because he advised the law enforcement of the presence of the gun would actually be punitive for him being cooperative with the police.
Specifically asked him if there was anything illegal inside of the car. And then that's when he proffered and said that there was the gun.
All right, I am going to make a finding of probable cause, but I am going to, of course, take that into consideration, the fact that he was cooperative when setting bond. Mr. Romero, we'll go to you.
Judge, Mr. Watson has no prior record. Based on that, Judge, I do understand ultimately it's a firearm, so I'm not going to ask for straight ROR. But based on my colleague's argument as far as the weakness, and I don't think it's going to get through a case file, I'm asking for an ROR on count 1. Oh, and the cannabis offense. I don't even think those are.
You want an ROR on 1 and 3?
Yes, Judge.
All right, state your response.
State would recommend keeping bond in place.
Does he have any prior history?
No, Your Honor.
All right, the bond on count 1 will be reduced to $500. I'll leave the bond in place on count 2, and count 3 will be an ROR.
Thank you, Judge.
Thank you. Good luck. Ladarius Butler.
Please approaching, Judge.
Good morning, Mr. Butler.
How you doing this morning, Your Honor?
I'm well, thank you. Mr. Butler, you're before the court this morning on 3 charges. Count 1, possession of weapon or ammo by other state felon. Count 2, attaching a registration or license plate not assigned to the vehicle. Count 3 is driving while license suspended without knowledge. Counts 2 and 3 are not for magistrate. I find probable cause, and I will hear from the parties.
Judge, Mr. Butler did advise me he has a prior record. He's not working at this time. He has a job interview that was scheduled for today, at Teleperformance, where he felt good. He was going to get the job where he was going to get paid $13 an hour. Considering as a prior record, Judge, he's not employed, but he's going to be employed, Judge. I'm going to be asking for a $2,000 bond on count one.
Before I hear the state's recommendation, Mr. Romero, I just want to advise you, because I know that you don't have the probable cause affidavit in front of you, so I'm just going to read you the last paragraph so that you can let him know. This says, Officer Butler, who is currently assigned to supervise Butler's parole release terms, is working on obtaining a warrant to have him extradited to Mississippi for violation of parole. So that's not before me right now, but I want him to understand that that's information that's in front of me. All right, State, we'll go to you.
Our state's recommendation is $10,000 for count one.
What's the basis for the request?
Your Honor, he has priors from Mississippi. February 24th, 2020, he was arrested for aggravated assault and domestic violence in Vicksburg Police Department. Yes, Your Honor.
Anything else? I'm also just noting that the probable cause affidavit indicates the charges he's on parole for include possession of a firearm by a convicted felon as well. Bond's going to be set at $10,000. There will also be an order that Mr. Butler possess no weapons, firearms, or ammunition. That should go without saying based on his present status, but I'm going to say it anyway. Mr. Butler, that means if you're in possession of any weapons, firearms, or ammunition, they are to be surrendered to local law enforcement. Do you understand that, sir?
Yes, Your Honor.
All right, thank you. Joshua James.
Judge, I have an argument as to counts 2 and 3.
Okay.
He's here, President Main Judge.
Thank you. Good morning, Mr. James.
Morning.
Mr. James, you're before the court this morning on 3 charges. Count 1, trespassing of an occupied structure or conveyance. 2, obstructing police while serving or executing a search warrant. 3 is possession of weapon or ammo by a convicted Florida felon. And Mr. Miller, I'll hear your arguments at this time.
Thank you, Your Honor. As to count 2, he's charged with obstructing the police and executing a search warrant. The statute reads, willfully obstruct, resist, or oppose. According to the probable cause affidavit, Mr. James was seen leaving a place where a search warrant was being executed. And so there's no active obstruction here. He's simply leaving the place where they can now execute the search warrant without him being in the way. I think there may be another charge that's more appropriate, but they don't require him to be present in order to execute a search warrant. This is not an arrest warrant, but a search warrant. And him leaving the scene of a search warrant is not obstructing it. And so I'd argue that there's no probable cause to hold him on that charge. And as I said, I believe there might be a more appropriate charge, but that's not it. And the second one, Judge, possession of a weapon or ammo, there's just no indication in this probable cause affidavit, at least that I saw, that there was a weapon or ammunition.
Do you have the second one?
Apparently, I don't have the second one.
State, will you please give Mr. Miller a copy of the second one?
Yes, Your Honor.
Thank you.
Do you want to look at it? That's the second page.
Judge, I withdraw my argument as to count 3. It would be nice if I got all this stuff ahead of time.
Okay. With respect to count 2, well, before I say what my thoughts are, State, do you have a response that you would like to make?
Yes, Your Honor. With regards to defense counsel's argument for count 2, the police were in the process of execution of the search warrant. They gave commands to the individuals and residents at that property, and several of those individuals, they willfully fled from the property, disregarding those lawful commands, and the defendant was one of those individuals who had fled, and the state would argue that there's PC here.
Judge, again, the language of the statute is clear. It's knowingly and willfully obstruct, resist, or oppose. And there's nothing in these actions that obstructed, resist, or opposed the execution of the warrant.
Okay, if this were a situation where Mr. James were simply fleeing the residence, then I may agree with your argument, Mr. Miller. The basis for my finding is going to be on the second probable cause affidavit that was provided. The sentence that I'm looking at reads, "As I reached the rear of the target residence, I encountered the defendant reaching into a cooler and placing a rifle magazine inside his jacket pocket." And then it goes on to say that Mr. James fled and was apprehended by law enforcement. In this situation where the officers are executing a search warrant on the property and Mr. James was allegedly seen by law enforcement taking physical property from that location, I do believe that that reaches the level that is needed for a finding of probable cause. So as to counts 1, 2, and 3, I am going to make a probable cause finding for today's hearing purposes.
The defendant was ordered to pretrial supervision on the 26th of February 2020 in case number 20813 CF10A. Second of March. Based on this court's finding of probable cause for this new arrest today, I'm going to ask that his pretrial status be revoked. Again, case number 20813 CF10A. The charge is carrying a concealed weapon by a convicted felon.
Was he actually released to First Step?
He was.
Okay. All right. Based on pretrial's request, I am going to revoke Mr. James' pretrial services in case number 20813 CF10A based on the recency in which he has received the new arrest. Was this trespassing in the old case?
No, that's a new case.
That's the new case. Oh, okay. And the fact that the charges in the case that was on pretrial involves carrying a concealed weapon, the case that's before us today relates to ammunition, not necessarily a weapon, but based on the similarity of those charges. In addition to revoking Mr. James's pretrial status in that case, I am going to order that he be held no bond in that matter so that his division judge can decide how to further address those issues.
And Judge, Mr. James is asking for the court not to revoke his release on pretrial release, but to keep him supervised and also keep him under supervision on the new law offenses.
Well, based on the fact that he has a new charge based on this arrest that's similar to the old charge, and he was not at First Step Sober House where he was supposed to be at as a requirement of his pretrial services, I'm going to respectfully deny that request. At this time, I will hear the parties' recommendations as to bond on count 3 in the case that is before me today.
United States recommendation is $7,500.
Mr. Romero.
And Mr. James cannot afford any sort of monetary bond, Judge. He's indigent.
All right, then that may be a matter that will be better addressed by his division judge. So in light of that, I will set the bond on count 3 at $7,500. And I'll leave the standard bond in place on count 2. There will also be a no return order to the location of the trespass in this case. Mr. James, do you understand the no return order?
Yes, ma'am.
Thank you. Julian Suarez.
He's approaching, Judge. He's here at Maine.
Thank you.
Good morning, Your Honor.
Good morning, Mr. Suarez. Mr. Suarez, you're before the court this morning on one charge of possession of a firearm on school property. I find probable cause for this charge, and at this time, I will hear recommendations from the parties. Go ahead, Steve.
Your Honor, the state's recommendation is $10,000 and no return.
What's the basis for the request?
Your Honor, it's just due to the nature of the charge and the facts of the case.
All right, Mr. Romero.
Judge, unfortunately, I haven't reviewed the probable cause affidavit, but something from what Mr. Schwartz advised me that I'm sure the state will correct me if I'm wrong. This is his first time being arrested. He's 55 years old and living in our community for almost 20 years. He works for Kent Security. He's a licensed security guard. He's been doing that for 1 year. He makes $11.25 an hour. He lives with his wife in Lauderdale Lakes. They reside in an apartment which they rent. They do not own, and they've been living there for the past 15 years. He's been married to his wife for 36 years. She's also employed. She also works as a security guard. Judge, my understanding is, and I know as far as the impression, the charge itself, what he's been arrested for, I understand why the state has concerns, but in speaking to Mr. Suarez, my understanding is I believe the school that we're talking about is Sagemont, located at Weston. My understanding, he works there as a security guard. He's not employed there in the capacity as far as being an armed security guard. My understanding, he's an unarmed. However, Kent assigns him to different school locations. His other location, I believe, is JCC. In that position, he is his job description does have him required to be an armed security guard.
Okay.
I believe when he was going to be finishing working his duty at Sagemont, he was supposed to go straight to JCC, and hence he didn't. That's why the reason of the firearm that we're talking about.
Okay.
I think it was probably a stupid mistake on his behalf, but I believe it was a mistake. Judge, I'm going to be asking, based on his lack of any priors, Judge, for a $1,500 bond on his behalf.
Say respond to that, please.
Go ahead.
Your Honor, the facts of this case is that it's at a school during school hours. He's supposed to be an unarmed security officer. He brings a firearm and then accidentally discharges the firearm and strikes another coworker in the eyeball. And he admitted to it.
All right. The bond in this case will be set at $7,500, and there will be a no return order until further order of the court to this particular location. Mr. Suarez, do you understand the no return order?
Yes, ma'am.
Thank you. Corey Butts.
Judge, I've been advised that's been reset for the PM. I think confinement status can shed more light on that.
Let's see.
They left off the charge. He actually has 2 counts of petty theft. So we removed them and have them administrated.
Okay, all right, that's fine. So you say that. Thank you. All right, next will be Juwan Brown.
Is it the main
He's
jail,
approaching,
Judge? We just have a request.
All right. Good morning, Mr. Brown.
Good morning.
Mr. Brown, you're before the court this morning on one charge of grand theft. I find probable cause. And Mr. Miller, what was the request?
Judge, for whatever reason, the judge who signed the arrest warrant in this case set the bond at no bond. I think Mr. Brown, unless there's something I'm missing, is entitled to a bond, and this is a third-degree felony. The convenience bond would normally be $1,000.
I believe that should have been hold for magistrate. So yeah, the no bond is placed incorrectly. All right, so at this time, I'll hear recommendations. We'll start with the state, and then I'll go to Mr. Romero.
Your Honor, there's no objection by the state to defense request for $1,000.
$1,000?
Yes, Your Honor.
Okay. Mr. Romero?
Judge, I believe that's, as my colleague pointed out, that's rightfully the standard bond. That's what should have been in place. But my understanding is Mr. Brown is 20 years old. He has no prior adult record. We're asking for a straight ROR. If the court's not inclined for straight ROR, then just leave the bond in place at $1,000. I'm going to be contacting his family.
Does he have any priors? Okay. All right, I will set the standard bond, so the bond will be set at $1,000. Thank you. Good luck, Mr. Brown. Lafayette Johnson.
Mr. Johnson?
Judge, I have an argument, but before I do make that argument, I would like to ask if there are any documents that I'm missing so that I can consider those before making any silly arguments this way.
While I am reading the charges, why don't you check with the state, okay? All right, Mr. Johnson, good morning.
Morning.
You're before the court this morning on 5 charges. Count 1, burglary of an unoccupied conveyance, unarmed. Count 2, dealing in stolen property. Count 3, resisting an officer, obstructing without violence. Count 4, fleeing or attempting to elude law enforcement. Count 5 is failing to stop or remain at an accident involving non-serious injury. Before I proceed with a probable cause finding, I'll wait to make sure that Mr. Miller has everything that he needs.
So I'm going to amend my objections to count 2 and 5.
Okay?
Count 5, failure to stop, remain in an accident involving non-serious injuries. The officer in the second report that the state was so kind to let me see indicated that there was a possibility of injuries, but never followed through with that. So I'd argue there's no probable cause. It may be a failure to stop and remain, but there's the injury aggravator is not there. And 2, dealing in stolen property. Unless the police are trying to say that having the stolen license tag is somehow trafficking in stolen goods, I'm arguing there's no PC for dealing in stolen property, and I would ask that he be ROR'd on that count.
All right. State your response.
Your Honor, just one moment, please. Thank you. Your Honor, with regards to arguments that defense made for count 5, it says in the PC that the vehicle was parked next to it. The vehicle fled fled the scene, later striking an additional vehicle at the location. And in the second report, it says that he observed him collide with another vehicle at the intersection. Possible. That struck the suspect vehicle.
I think the argument Mr. Miller's making is with respect to the injury component, not to the accident component.
Yes, Your Honor.
The state doesn't see anything that says about injury here.
Oh, before we move on to count 2, I will fine PC for failure to stop or remain, but not with respect to the injury component. All right, and now state your response to count 2.
Your Honor, it says here in the second probable cause affidavit that the vehicle was bearing a stolen tag. And furthermore, the vehicle was mentioned as being involved in fraud, burglary activity weeks prior in the city of St. Petersburg. And it was also identified as being involved in 2 burglaries in the city of Pompano Beach moments before the accident. And the vehicle had refused to stop despite numerous marked units with lights activated and police helicopter.
All right, I am going to find no probable causes to count 2. I realize that it references a stolen tag. I don't think that rises to the level of dealing in stolen property. So count 2 is going to be an ROR. Before we move on to the other counts, I don't know it off the top of my head. Do we have a standard bond for failure to stop or remain in an accident?
It's a misdemeanor, Your Honor.
All right. All right, so at this time, I'll hear the parties' recommendations as to the remaining counts.
Your Honor, for count 1, the state would recommend $5,000, and for count 5, state would recommend $1,000.
Mr. Romero?
One moment, Judge. Judge, count 1 is a 3rd-degree felony. I'm going to be asking if the court would consider reducing it to $2,500. On count 5, the misdemeanor offense, I believe the standard bond would be about $100. So I'm going to be requesting $100 for count 5.
All right, the bond on count 1 will be set at $3,500. The bond on count 5 will be set at $750. I'll leave the other standard bonds in place. There will also be an order of no return and no victim contact. Mr. Johnson, so that you understand those orders, that means you're not to return to the location this allegedly occurred at. And with respect to the no victim contact order, whether you know the alleged victim or not, that means no being in the same place at the same time as this person, no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that, sir?
Yes, ma'am.
Thank you. Stephen Syriacs.
North Broward, Your Honor.
Mr. Barrows actually have Paul Ryan.
It's Syriacs. Syriacs.
Says no paperwork on the docket. So I didn't have him brought down.
What was that?
That caused some confusion,
Okay.
because they didn't have paperwork yesterday, why
Okay.
they're putting him on here today like that, but, there was some confusion about that.
Right. Okay, so, why don't we have him reset for this afternoon? Okay, Deputy, we're gonna have him reset for this afternoon's docket, okay?
Okay, now Your Honor, he did come yesterday,
Yes.
and after he spoke with Mr. Miller, he said that
He left.
wasn't bonded out, so he.
Well, I'll reset him for this afternoon. If he doesn't wanna come, that's fine, you just let me know.
Okay.
But I'll give him
Okay.
the opportunity if he wants to come, okay?
Okay.
All right,
Will do.
thank you.
All right. You're welcome.
Yeah, yeah. Will you, save this one for me? Yeah, I remember that from yesterday. Okay, next is James Stephen Anthony.
In jail, Judge, we may have the same problem there as well.
Oh, really? And let me just ask on his, he's only here on 4 and 5, right? Okay,
We represent him on the other matters. I don't have no objection if this court passes him through. He's gonna see his division judge on Monday.
all right, so they didn't pull him at Maine, right? Yeah, oh, it's the VOP, so based on what Mr. Miller's telling me, I'll go ahead and find probable cause so we can go to the division on Monday. Thank you. Next will be Silvio Barrios.
Paul Ryan, Your Honor.
Thank you. All right. I changed it yesterday. Okay, all right, good morning, Mr. Barrios.
Good morning, Judge.
Mr. Barrios, you are before the court this morning on 3 charges. Count 1, possession of cocaine. Count 2, tampering with or fabricating physical evidence. And count 3 is having an expired driver's license over 6 months. I find probable cause, and I will hear from the parties. Is the state seeking anything beyond the standard bonds?
Okay.
Okay, Mr. Miller?
Nothing, Judge.
All right, I will leave the standard bonds in place at this time then. All right, Mr. Barrios, good luck to you, sir.
Thank you.
You're welcome. Christian Bernal?
He's a North Broward judge, and believe it or not, I have an argument.
Good morning, Mr. Bernal.
Good morning.
Mr. Bernal, you're before the court this morning on 2 charges. Count 1, threat to throw, place, or discharge a destructive device. Count 2 is a parole violation, which has a no bond hold. Mr. Miller,
I need to pull up the statute.
if you're going to make a probable cause argument, I'm just gonna go ahead and tell you the same thing I usually say, which is that Judge Casey has already found probable cause in this case.
All right.
Yes, in Christian Bernal's case.
Oh,
Judge
right.
Casey signed an affidavit, signed the warrant.
I understand, Judge, but as far as his bond amount, $25,000.
Yes.
I'm arguing that this is, once again, a statute that is misapplied.
Okay.
In this case, what we're missing is the device. And the statute requires that there be a threat to throw or to discharge a device. In this case, Mr. Bernal is alleged to have made statements saying that he wished to blow the place up, but there was no device involved, no paper bag with a fake bomb, no no, I think one of the cases that I reviewed, it was a hand grenade. And so there's no actual device, and that's required by the statute in order for him to be charged under this. I understand that the language that he used is highly objectionable, and I understand that.
I never even said that.
Mr. Barrios,
Mr.
okay,
Bernal.
Mr. Bernal, do you want to do this? Because I can just step aside, let you take.
All right, Mr. Bernal, you just listen for now, okay?
Okay.
All right.
So the language is objectionable, the sentiment is highly objectionable, but it's not a crime under this statute. Might be another statute that's appropriate, but to charge him under this statute, I think is inappropriate. I understand the judge has already found probable cause, but considering the fact that this statute is misapplied, I'd ask the court to release him on his own recognizance on this count.
All right, the state's response.
Your Honor, the state would recommend keeping bond as is. He goes to the reentry center. He starts becoming angry, yelling, slamming his fists, says that he's going to start killing black people. Then he says, I'll blow this place up. You guys don't know what I'm capable of. Then he continues. Then he continues.
Mr. Bernal, I would strongly suggest that you remain silent at this time. Do you understand
I
that?
said, I'm just laughing.
I would suggest that you remain silent. That includes laughing.
All right, whatever you say.
That's correct. Thank you. Please continue.
Then he continues by saying, I'm going to blow this effing building up with all these bees in it. And then he told the next, he said the next black person that disrespects me, I'm going to kill them. And then as he continues, he blocks, he gets very close to the person and he positions himself in a way to block her. Then he starts slamming his fists on her desk, waving his arms in an aggressive manner. Then he threatens to blow this place up. It's threatening to set off some type of explosive or bomb at the day reporting reentry center and put all the occupants and everybody in fear and safety.
Okay. For the record, I am going to formally make a probable cause finding since Judge Casey has already found probable cause in this case. Mr. Miller, I do note the arguments that you've made today. I think that based on the fact that Judge Casey's already made a probable cause finding and in light of the fact that Mr. Bernal has a no bond hold with respect to the parole violation, this may be an argument that's better suited to be addressed with his division judge. So at this time, I'm going to leave the bond in place as set by Judge Casey. There will further be an order of no return to this location.
It's all fucking lies. Fuck all
Deputy,
that.
would you do me a favor and turn the speaker off at North Broward, please? Thank you. There will be an order of no return to the location this occurred at, and there will be an order that Mr. Bernal possess no weapons, firearms, or ammunition until further order of the court. Mr. Bernal, that means if you are in possession of any weapons, firearms, or ammunition, they are to be surrendered to local law enforcement until further order of the court. I further need to advise you that because you have the pending parole violation, which has a no bond hold, you will go before the parole board in order to address that matter. Thank you. Howard Lowell.
Medical research on it.
Thank you. Was he a medical reset from yesterday? All right, we'll just have a reset tomorrow. Next is Rodney Rodriguez. All right. Good morning, Mr. Rodriguez.
Good morning, Your Honor.
All right, Mr. Rodriguez is here on a change of charge. The charge is being changed to attempted first-degree murder. State, I just want to confirm that at the first appearance hearing, was probable cause found for attempted first-degree murder already? Okay. Okay.
And Your Honor also found proof evident presumption great.
Okay.
And we're not prepared to make any arguments today. He's going to be arraigned on the 26th of this month.
Okay, so then I'm just going to replace the original findings. I'll replace my finding of proof evident presumption great without prejudice, and I will replace the no bond hold that is in place at this time. So it will just remain, Mr. Rodriguez, essentially, because this is just a technical change, the bond and release conditions are gonna remain as they were already set, and you'll be able to go before your division judge in order to address that in the future. Good luck to you, sir. All right, next will be Jose Juarez Tomas.
He's gonna require a Spanish interpreter. The interpreter's not there, we can reset it till 1 in the afternoon.
We can reset it. He's just coming on the ad charge for the immigration hold, so we'll reset it for this afternoon.
Thank you, Judge.
Okay, will you hold that for me for this afternoon? And then, last on my list is Tyrick Turner.
He's approaching, Judge Main.
Thank you. Oh, thank you. All right, good morning, Mr. Turner.
How you doing, man?
I'm well, thank you. And Mr. Turner is here on a perfection for counts 1 and 2, which, once again, those are for grand theft of a firearm and possession of weapon or ammo by a convicted Florida felon. If you will just give me a moment to read the report that was provided to me. And have you already received this?
I have read that, Judge,
All
and
right.
I would concede count 2. I would argue that there's no change as to count 1.
All right, just give me one moment. All right, does the state have a response on count 1?
Yes, Your Honor. The
ahead.
state's response is that there was an inventory search that was done of the vehicle, of the defendant's vehicle, and that revealed the gun with the handgun number, and that when they ran it, it was stolen out of Miami-Dade County with that case number, and it also revealed that the defendant is a convicted felon, and he was convicted of those other offenses.
Mr. Miller, anything further?
That was the same argument that was made yesterday, and the court found no probable cause, and they didn't supplement that particular charge.
All right. Okay, for today's purposes, I will find probable cause as to count 2, but I will remain at no probable cause on count 1, which will place that at an ROR. I believe we already addressed counts 3 through 8 yesterday with respect to bonds. So at this time, I'll hear the parties' recommendations on count 2.
Judge, we're gonna, sorry.
I'm sorry, can you repeat that? I didn't
I
hear.
was gonna be requesting a $2,000 bond on Mr. Turner's behalf. He is working. He works for Prestige Cuts. He's a barber. He's been doing that profession for about 15 years. On a good week, he can make about $350. He lives in Hollywood with his girlfriend. His girlfriend's the person that is going to be reaching out to help post his monetary bond. She works at Starbucks. I believe she's a coffee barista. She's not going to be able to afford more than about $2,000. That's why we're requesting that amount, Judge.
Okay, state.
Your Honor, state is gonna. One moment, Your Honor. Your Honor, state would be asking for a $5,000 bond.
Okay, what's the basis for the request?
Just due to the nature of the charges and the severity of the case, and we're just.
he out on bond in that case?
It appears that way off of Miami-Dade.
Oh, it's in Miami, okay. All right, the bond on count 2 will be set at $5,000. And I'll leave, all the bonds that we discussed yesterday, those are the standard bonds, they were gonna remain. All right, thank you. Good luck, Mr. Turner. All right, that brings us to the end of our morning docket, so I will see everyone at 1 o'clock for the PM docket. Thank you.
Thanks, Your Honor.